Great to be here. Sorry I couldn't have been here earlier, but COVID test. Also, I was glad to see everyone running from the doors when it started, so you guys made the foolish decision to stay. Interesting choice. Last presentation of the day, a lawyer. Let's see how we go. Now, I was initially meant to be speaking yesterday, but because I was meant to be in Byron Bay, I was moved to today. And so firstly, thank you to the team here for accommodating me. No thank you to COVID for me not getting to Byron Bay. But it does mean that I'm a little bit social media slant rather than digital slant today, so I apologise if that is going to upset anyone. The other thing, though, is that I have allocated quite a bit of time for questions, so please start thinking of your questions now. Some ideas could be, how disappointed are you that you didn't spend the last 2 weeks in Byron Bay? Just an option. It is great to be back, and as Ravina said, I have presented at most, I think, if not all, social media days, digital Adelaide days. And you would have seen that this year they were marketing hard on the inspiring and practical speakers. Amazing list that you'll see there, really great people. You might not have seen the fine print, which I was very pleased that they added, which was that you would today be hearing. So that's what I'm here to deliver. I'm here to destroy your dreams. So thank you to the team. But it's been a weird year. I think everyone can agree on it. Every possible front, it's been a weird year. I mean, does everyone remember, I was preparing this presentation, thought, what's been happening? And then like, oh yeah, Facebook decided to shut down everything for everyone because they didn't want to give Rupert Murdoch some money. Now, I appreciate the sentiment, but it was a little bit challenging for everyone in social when that happened. Obviously, there was an agreement reached and everybody won, I think, maybe. I don't know, everyone claimed victory, but it was all very confusing. But there actually has been some substantive change that wasn't just Pyrrhic victories reported in the media. And so today we're going to be looking at some changes to the law, what happens if legislation doesn't keep up with the way in which society is moving, a couple of case updates, some things to watch, and then over to your questions. This is, sorry, I'm going to be the boomer here. This is from a TV show, so that was not streaming, called Jeopardy. Oh, cool, it is streaming. Nice. So this was Jeopardy. But anyway, as usual, and as with everything I say on the various Facebook communities, I am a lawyer, but this is not legal advice. This is general information only. If you need legal advice, go speak to a lawyer. If you also need Microsoft Paint skills, there's my standard calling card. I have this is an old joke. For those who have been here a number of times, I have been working on my Microsoft Paint skills, so that's this year's entry. Feel free to get in touch. I'm always happy to talk with anyone who has a legal question in this space. So, first up, let's talk law reform, because everyone here I know has been super excited and following very closely the changes to the uniform defamation laws in Australia. Hands up who's fully across this. Awesome, cool. All right, I'm glad to know where the audience is sitting. That means I can hit it at the right level. So, very brief history of defamation, and this is relevant for pretty much anyone who does anything online, because the way things are today, if you sneeze online, someone will sue you. So who can remember pre-2005? I mean, pre-2020 seems pretty far away. But back then, defamation laws were state by state, and there wasn't really much uniformity in how it was treated. You used to have things called libel and slander. We don't have those in Australia anymore, so if someone threatens to sue you for slander, they've been watching too much Law and Order, or not enough. And also, obviously, Brad Pitt and Jennifer Aniston were married back in 2005. That's how different the world was. Then in 2005, some really important things happened. I'll let you read those ones for yourself. But Importantly, Australia adopted uniform defamation laws, and so that we went from this thing where if I said something bad about you in Perth, it would be potentially handled differently if I'd said it in Adelaide. Whereas from 2005, it was pretty much the same across the country. And so defamation at that time had a much clearer definition. So what is it? Well, it is a statement which tends to lower a person in the estimation of his or her fellows by making them think less of him or her, according to Fleming's Law of Torts. But it's basically anything that would make you less popular or thought of less. So, for example, not being included in a list of inspiring and practical speakers could potentially lower someone's estimation of you. Importantly, though, there are a couple of things that are required. I can walk up to you in a private place where no one else can hear us, and I can call you every name under the sun, say the most awful, defamatory things possible. But, sorry, wrong slide. That is not defamation. To be defamatory, there must be publication to a third party. In comes the internet, and suddenly, the moment you post something online, it is definitely published to a whole lot of people. At the moment, under the Uniform Defamation Laws, only certain companies can sue for defamation. So if you're an individual or a partnership, you can absolutely sue for defamation. If you're a not-for-profit, even though you are a company, you can sue for defamation. And if you are a company with fewer than 10 full-time equivalent employees, you can sue for defamation. Out of that category, sorry, you should be big and tough enough to handle hugely unfair and defamatory comments. Unfortunately, the dead cannot sue for defamation, so anyone who is planning a seance-based defamation trial, I can't help you there. If you've got 10 or more employees, local governments can't sue, but that does not stop a substantial amount of my practice being from local governments, because whilst these entities, so companies, local government entities, state government, federal government entities, can't sue for defamation, all of their employees, elected members, directors, etc., are individuals who are capable of suing for defamation. So the legislation tried to really limit who could sue and didn't really succeed. And so because of that, we've had a push for more reform to defamation. And part of that has been brought forward because of changes to the way in which the courts have interpreted the elements of defamation. So the first thing that we've got is the question of publication. Have the statement that's been made that is defamatory of someone else been published to a third party? And if so, when? Particularly in an online world, the date on which the publication is published is relevant, because you only have 12 months from when a publication is made to bring an action in court. If you can show that there is a good reason why you didn't, so for example, you can't have known about that post having been made within that 12-month period, you have a further 2 years in which you can bring the application, but it's much, much harder. The court's position at the moment, though, is that whilst something remains online, it is a continuing publication. So even though you might have made a comment about me on my MySpace page 8 years ago, yeah, checks out, if it is still there today, I can still sue for defamation. I'm going to jump back and forth, sorry. That is going to change under what is called the single publication rule. So the law reform that's coming in, and it's coming in some states, so New South Wales has it at the moment. We don't get it in South Australia, but we're going to get it in the next month. There's going to be a single publication rule. And that is going to mean that you only have 12 months from when the content was first published to take action for defamation. The other elements that we're going to see is a change to some of the thresholds to bring defamation and some of the defences. So at the moment, if you say something that is true, such as the fact that I am the destroyer of marketers' dreams, then that is not defamatory. If it's an honest opinion, if it's trivial, if it is something that you have a duty to tell someone, so for example, telling the police, I think I saw someone doing something wrong, that is covered by what's called qualified privilege, and you have a defence to defamation. Part of the changes that are coming in, though, are recognising that society expects there to be somewhat different tests. So we can all remember the rather high-profile defamation cases brought by Commonwealth ministers about comments made about what may or may not have happened some time ago. And I'm not going to go into further detail. Everyone should, I assume, know what I'm talking about. At the time when that case was brought, there was no public interest defence to a claim of defamation. Now, the new laws are going to say that if what you are saying is in the public interest, so we have heard allegations that Mr. Bloggs has done X, Y, and Z, even though it may be defamatory, it's untrue and it is not something which can be justified, it may be in the public interest for people to know that the allegation has been made, and so that is now going to be a defence. The one that's really interesting is that they're bringing in what's called a serious harm test, which basically means that before something can be defamatory, it must have reached such a level as to be able to cause serious harm. Now, I don't understand how that differs from being trivial, because you would have seen that there was this defence of triviality, and so it's not really a change, but we'll see how that all washes through. So we're now in a position which is kind of sort of like where we were before 2005, in that as of today's date, there are different defamation laws that apply in each state and territory. We will presumably within the next 6 months get back to a uniform position, but this is where we're going. It's an interesting line of changes that they put through, because what they haven't really addressed was the biggest issue that we've seen in defamation and an online environment in the last few years, which is the case of Dylan Voller. Now, let's say, has anyone here not heard about the Voller case? Okay, excellent. That justifies me going into it. Dylan Voller, you may have seen in the news years ago, was one of the detainees at the Dondale Detention Centre. And there were some rather alarming images posted of him tied to a chair with a spit hood on. Now, a variety of publications wrote articles about this, and they promoted those articles on their public Facebook pages. The public, being the scum that they are, decided to post a whole bunch of rather unflattering comments about Mr. Voller in response to those articles. Voller sued not the people who had made the comments, not the platform upon which they were posted, being Facebook, but the news outlets whose public pages those were. In an initial judgment by a single judge of the New South Wales Supreme Court, there was a decision that basically said anyone who has a public page on a social media platform has an obligation to pre-moderate content before it is visible to the public. The judge did not seem too worried by the fact that there is no inbuilt functionality that allows for this to happen on most platforms, and in particular Facebook, which was the platform in question, and suggested that instead people needed to gaffer tape together a content filter by using the profanity filter and just insert every known word that you can think of, not recognising that people could then still post images which contained words. So it was a weird judgment that was then upheld on appeal. So the full court of the New South Wales Supreme Court looked at it and said, yeah, we reckon these guys are publishers of the content that has been posted. And this does sort of kind of follow a line of authority from other cases we've talked about in these sessions in the past, where the general position was, if you have an ability and means to review and moderate content or even respond to it, and someone posts up something that's either unlawful or misleading, you have a duty to respond or delete or deal with it. But it's gone that one step further of saying it's not just when it's reasonably possible for you to see that content, you have to do it in advance of it becoming public. So we're now in this situation where that is the law. Uniform defamation law applies across the country. New South Wales came out and said, you need to pre-moderate content. It is currently in front of the High Court. Google Images free stock gallery tells me that that's the High Court. Maybe, seems plausible. Arguments have been heard and judgment has been reserved. So we do need to watch this space to see what will happen in relation to obligations with respect to pre-moderation of content. Does anyone here pre-moderate their content on their pages? Good for you. I'm impressed. Yeah. Can I ask, are you using the profanity filter on Facebook in order to pre-moderate? Yes. There you go. Apparently the courts were right. It's easily done and functional.
Yeah, so we have a lot of words, and for a while there, when they're especially in politics, there were a few cases recently that came up, obviously around Canberra. Everyone probably knows what's been going on there. We knew who the woman was involved. We knew the politicians. Their names all straight away got put in our filters. So no one could then go and name them in our comments and our stories. That defamation incidents of naming and shaming people on social media, and to moderate every comment that you could possibly have, even if we've had comments that have come under like a koala image calling out a politician or calling out someone where you wouldn't have expected it to pop up, but people have gone, I need to get this to the ABC, I'm going to put it in every post they have on their page, and I'm going to name and shame these politicians doing inappropriate things in Parliament.
It's really interesting to see the practical example. I mean, I guess the challenge that you'll have is that you can't think of every possible variation of, Mischian Rorter or whatever it is. And I'm not saying that anyone with that name or any name that sounds like it has ever done anything inappropriate ever, but as an example, I mean, you can have the actual name in there, you can have replacing S's with dollar signs or whatever it is, but I think my concern with the legal element of it would be that it would be so easy for people to get through that net.
Yes, and the amount of creative ways that someone could spell the word fuck astounds me, because people literally will first write it out, we'll put it in our profanity filters, and then like a month later they've got the dollar sign, they've got another little smiley face in there, or they've done capitals and small cases, and just people get around swearing quite interestingly to try and get their comments on, even though they probably know it's not the right thing to be doing on a news page, but it's hilarious how creative people can be when they really want to get a point across, and they will find, those ways to put them in the comments.
And I guess the one other plus side of all of this is it hopefully has meant more funding for moderation staff. So there's a positive, I guess. So in relation to other social media cases we've seen, it has been a reasonably busy year. We've seen a 73-year-old man awarded $120,000 in damages and $85,000 in legal costs over a defamatory Facebook post by a fellow churchgoer, which I thought was a lot of money, and good for him on being digitally active, I guess, and being aware. You might have all seen that a mayor in South Australia had to apologise, not for commenting on, not for posting, but just for liking an offensive comment on Facebook. We have seen, I think I've talked previously about the emoji cases, that apparently a poop emoji can be defamatory. Query if the defense of truth can sometimes apply there. We've currently got a case that is before the courts involving the ex-Tour Down Under boss who sued over posts made by a prominent person in Adelaide about who was in fact responsible for the Tour Down Under and those kinds of things. So these cases can be, I see them reasonably frequently. I mean, the majority of times we have to remind people that whilst you do get the outlier cases, $120,000 and all of that, most social media defamation cases will have a judgment in the realm of $5,000 to $30,000 in terms of your return. And that's before you then take out your legal fees. So often, people will not get what they want. But from it was an interesting change to the laws in that they're trying to make it harder for people to resolve these disputes. My suggestion had been that instead what they should be doing is looking at creating like a tribunal. No lawyers, everyone just rock up, say, here's my issue, and then have Judge Judy style justice. But apparently they didn't take that on, which is good for me because it means I can still take on cases like this, but still it is interesting that these things continue to happen. Now, another area where we are seeing some reform, or at least some reform suggestions, is in the realm of privacy. Quick revision, who here thinks that we have a right to privacy in Australia? I've got a couple of little ones, so we've got a couple of people who think. So thank you for being brave enough to raise your hand. I'm sorry you are wrong. So, in Australia, there is no right to privacy. We have got a piece of legislation called the Privacy Act, and the Privacy Act does provide people with some protections, but that's not a right of privacy. It only regulates businesses that have a turnover of $3 million a year or more, health service providers, which includes personal trainers, gyms, and weight loss clinics for some reason, and people who deal in data. So if you are buying and selling databases, then you are an APP entity for the purposes of the Privacy Act. We also have the extraterritorial reach of the Gdpr, which is the big, scary thing that we were all talking about a few years ago, which actually has led to a number of non-EU companies facing significant penalties, though not many in Australia. Under the current system, if someone breaches your privacy, you can't do anything other than complain to the Privacy Commissioner. So the Privacy Commissioner has the sole ability to decide whether or not it's worthwhile taking action for a privacy breach. Additionally, at the moment, direct marketing and use of sensitive information require consent, but other forms of collection of personal information simply require notification to the person whose information you've collected. So if you are going out and collecting people's information, you're doing some form of review of social media posts, or you are collecting people's email addresses as part of your mailing list, etc., you really have obligations only to tell them what you're doing and only to get their consent if you are targeting them for marketing purposes via their personal information. Now, since then, we've seen the legislation not do a great deal. So privacy reforms came about in Australia around about 2014. Since then, we've had mandatory data breach notifications come in 2018, but not a great deal else has really happened. And so we're now seeing private entities starting to fill the void where parliaments have failed. So everyone here familiar with what Apple has been doing? Have you seen those ads on TV where, disturbingly, people are popping out of existence? Effectively, iOS 14.5 is saying that apps must specifically request permission to collect information. There are limits on the use of biometrics. You are responsible if you use a single service, what is that acronym? I'm going to look over. It's using the single login access. Single sign-on, thank you. One of those days. You are responsible if you are making use of Facebook login or Google logins if something goes wrong with that information. You are also now prohibited from incentivizing people giving you their data via apps on the Apple App Store. This is a substantial change to how things were prior to this release and is very different to how things operate under the Google ecosystem, the Android ecosystem, Alphabet ecosystem. And it might be, to my mind, a sign of people trying to now create some form of competitive differentiation around privacy, because up until this point, my sense at least was that privacy was something that people felt very passionately about until you asked them if they really wanted to be able to play Candy Crush. At which point, so it will be interesting to see whether or not this leads to a massive group of Android users throwing away their Samsung devices and grabbing iPhones, or if it's going to mean that developers are moving away from iOS to Android, because that is where they are free to harvest our personal information to their heart's content. But it is very interesting that this has not come from governments, because governments have been talking about this for quite some time. And whilst Apple isn't the biggest smartphone manufacturer in the world, they hold a significant market segment such that this does have repercussions for the way in which people do business. It may, however, also be simply them trying to get ahead of the curve before something that they think is coming eventuates. So we had the GDPR in Europe, and that pretty much codified a lot of what Apple is doing anyway. We're now seeing the US government taking action. So one advantage of me being really late and giving my slides in is that this is reasonably up to the minute, that on the 9th of July, an executive order was passed by the Biden administration saying that heads of all agencies shall consider using their authorities to further the policy set forth in Section 1 of this order, with particular attention to unfair data collection and surveillance practices. Now, that does not have force of law in the US in that it doesn't require companies to do anything, but it is effectively instructing government agencies to take a look at what they can do with existing powers. And a number of US Congress people have been saying that they're going to try and make this into some form of law. And it might actually happen because of the negative sentiment towards social media companies on the right and the negative sentiment towards privacy breaches on the left. So who knows? We might actually see something happen there. Closer to home, we've just been given an exposure draft by the Attorney General about the new laws that they're considering here in SA to protect privacy. This follows a line of case authority where we've seen people trying to establish what's called a tort of privacy, so a general wrong of invading someone's privacy, which started probably 15 years ago in the High Court, where they said it might exist but didn't say it definitely did. This is the fun of the law. And then a number of magistrates' courts decisions here where a particular prominent family who are connected with a motorsport park in Tail and Bend built a house, and that house had some cameras on it, and the neighbour's house had some cameras on it, and they both just didn't like each other and alleged that the cameras looking into each other's yards infringed privacy, notwithstanding the fact that there is no particular right to that. So we are seeing that the courts are kind of pushing us in this direction, private sector's pushing in this direction, and now the legislature are pushing in the direction of having protection of individuals' privacy. And so the current law in the exposure draft would be if you have a reasonable expectation of privacy, there is an intrusion into your seclusion or a misuse of private information, and what occurs is serious, and you intend to use it in a way which would be reckless or would intrude into their seclusion, then you will be in breach of this law. That will obviously apply to people with security cameras, but it will equally apply to people collecting information on people who are going through their apps, accessing their websites, communicating with them via chatbots. All of that will involve the collection of personal information, and suddenly this law is not going to be limited to businesses with $3 million turnovers. If you are in the lofty $2 million turnover category, suddenly you're going to be impacted by this. It is only draft. It is out for comment and exposure. We don't know what the final piece of law is going to look like, but it's coming. So, where to from here? We're still waiting to see whether or not the change to the term the new requirement of serious harm is going to change how defamation works. We still don't know how the High Court is going to look at the decision in Voller. And the other important thing to remember with Voller is that this is just the question of publication. We haven't got to the defences yet. So that's going to be still has got a long way to go. We don't know if we'll get a new Tort of Privacy. And we also don't know if Clubhouse will actually be a thing in 12 months' time. Is it still a thing? Can anyone tell me? Because I went on there the other day, I was like, I don't know what's going on here. But I am also an elder millennial, so who knows? So hopefully if I'm asked back next year after forcing them to change my spot, shaming them for not including me in a list, and threatening a COVID prohibition on me presenting, I'll be allowed back next year. But, feedback forms are important. That's my very quick synopsis of the last 12 months. Does anyone have any questions? Excellent.
Okay, so free legal session now in progress with Paul. Thanks to Woolmans for sponsoring our event. You would have been using their Keat cups if you grabbed your coffee from Sorelli over the last couple of days. And also thanks to Woolmans for letting Paul come and not charging us $1 billion, because we don't have it. We've got enough money to put money on the bar though, so hopefully you'll be joining us at the Strathmore. Okay, first questions. In the back corner, over here.
Hey, I have a question on privacy. So if someone buys something from your online store that doesn't say yes to receiving newsletters and whatnot, what can you actually send them? Can you only send them about their order, updates, and that's it? You can never contact them again? Or are there weird loopholes where you can actually be well, you haven't purchased in 6 months, and technically that relates to their order? So.
Yeah, so this is actually something that's coming up more and more frequently for some reason, and I think it's because in a COVID environment, it's a lot harder to market to people. The way in which the privacy principles act, and I'm going to assume that your business is covered by the privacy principles in this context, because if it's not, go for your life, just send everyone everything, other than the Spam Act, which actually says you shouldn't, so as I said that, I realised my mistake. Under the APPs, the initial position is you cannot use someone's personal information to target marketing of a product or service to them. Full stop. Unless they have given their consent for that to occur, or it would be reasonable to think that they would expect to receive it. So, what you may wish to do, instead of asking if they wanted to sign up to your newsletter, or things like that, you may want to say to them, in your privacy policy, we may from time to time send you information that we think you might be interested in. Now, you do need to make sure that you are Spam Act compliant, in which you need to, before sending unsolicited messages to people, say also, if you don't want to receive this, here is a super easy way to opt out. And, I cannot emphasize this enough, honour the opt-out. The biggest problem people face is having an opt-out option that is either clunky and therefore people can't follow through with it because you have to do 14 different steps. Are you really sure you want to unsubscribe? Or it just isn't respected, and so people click unsubscribe and then the next day they get a newsletter on a slightly different product from the same people. Unfortunately, there is no risk-free way to handle this, because If you are direct marketing, you do technically need consent. I think that there is an argument to say that if someone has purchased products from me in the past, they might be interested in hearing about future products. So I wouldn't have a major concern with the business doing that, as long as they made it super clear and super easy that it's possible to opt out and to do so easily.
Thank you.
Great. I think we've got a couple more questions down the side here. I'm not sure what I think one of the mics ran out of juice, so we've just got one running around, so. Thanks, Lena. Yep.
Just want to quickly ask about the profanity filter. So obviously it's absolutely not possible and we don't have the resources in our organisation. But part of my defence is going to be, did you have a profanity filter? And I'm going to go, yes. I did everything within my power. Is that where we sit with this sort of thing?
No,
I'm still screwed.
It used to be. So prior to VOLA, the position that had been articulated by the courts, by the regulators, was always, it depends upon your situation. So if you were a one-person operation, sole trader, there was not an expectation that you would be there every day, every hour, checking to see what people had posted. But if you were a multinational with the resources to do so, then you had to get that stuff down much faster. VOLA did not make the distinction. They literally said, you have an obligation, there's no question of reasonableness. If it's up there and you didn't moderate it, too bad. So as it presently sits, even if you use the profanity filter to the best of your ability, if something sneaks through, you are responsible. So it is a completely unreasonable situation to place businesses in, I agree. It may be overturned by the High Court, who knows? Maybe if it isn't overturned by the High Court, then a pre-moderation functionality will be built into the platforms, because that would be probably the sensible way to sort this stuff out, is to say, have an option to say that I need to okay everything before it comes up. But yes, unfortunately, whilst I agree with the injustice of it, I don't have a positive answer for you. See my first slide, destroyer of dreams.
Yeah, you should add that to your LinkedIn bio.
I really should.
Catherine, back to you.
So
Clubhouse.
one thing that has come up through this conference over the past 2 days has been user-generated content. And we, as the ABC, use a lot of user-generated content, but we continuously ask for permission before we use it. But we've had a lot of photographers and small businesses who have posted content, whether it be a photo or a video, and someone else has taken that content, used it in a commercial sense or used it in another area. And I know it's forever changing and it's different when I did media law back in the day. What kind of legal sense does a small business or a photographer who's spent, all this time in doing these great photos, when someone takes their product and then goes and uses it on their platform and doesn't credit them at all?
Yeah, okay. So in general, user-generated content is great if you have permission. However, if you do not have permission either directly from the person who has created the content, or you are using it via an inbuilt resharing functionality of a social media platform, your use is infringing their copyright, whether you credit them or not. So crediting solves the question of moral rights. So everyone who creates something has the right to have it attributed to them, not to have it attributed falsely to someone else, and not to have it used in a derogatory or demeaning sense. That's what crediting fixes, but it doesn't fix infringing copyright. With UGC, sorry, I'll get it the right way around, unless you can point to having the actual creator's permission when you're reusing it, then you are infringing copyright. So if I see something on the ABC and I take that and use it for my own purpose, then the ABC is fine. You guys have got permission. I don't. I don't have, by virtue of your posting it, the permission to use it in any way, other than if you have posted on a platform and I use that platform's inbuilt resharing tools. So if, for example, I run a coffee shop and someone's taken a photograph of that coffee shop, you as the ABC have said, hey, can we post this on our Facebook page? And then I've reshared that story, absolutely fine. I'm not doing anything wrong. If I take that image, download it and upload it somewhere else, or put it on a poster, or just show people the photo on my phone, then I have got a problem because I am then infringing the user's copyright. Important point, some people think that you can use a hashtag to okay the use of user-generated content. Unless you can prove that the person who uses the hashtag knew that it signified giving you permission, it is a risky way of doing things. In terms of the remedies that people would have, so if I've taken a photograph, ABC have used it, and then Robina's stolen it, then I can take action against Robina for having stolen it. Sorry, Robina.
That's fine.
She's got enough lawsuits coming her way, one more won't hurt.
Yeah. Yeah, I'm pretty sure he's going to sue me for forgetting to put him on the Eventbrite page. Sorry, Paul.
But no, that's pretty much their remedy. Unfortunately, that's generally expensive and long, but it is something that they can absolutely do. Does that answer the...
No, it's good. Like, we're pretty good in contacting people, but the amount of times they message and they go, oh my gosh, a commercial station has just taken our thing and taken it out of context and put it up and done. And I was like, Channel 7 and a few other companies have a very different way of, they see it on Twitter or Facebook and they can just use it straight away and they can get away with it because they've got a huge legal team behind them that can, you know, but a small business or a photographer, you know, when they're messaging us saying, you know, I can't believe they've done this, what we can do. And I said, you can contact them, but we're talking so much this past few days, and we've had people take stuff from our page and blatantly tried to make it their own. And I've had to message them and say, hey guys, you haven't even credited us. And luckily we've got ABC branding on most of our stuff. But I think there's a few small businesses here and photographers that would be like, this happens to me all the time. What can I do against a big company? Yeah. You know, it's hard, it's tricky. Look, it happens all the time. And I get inquiries quite frequently about these things. So there was a really good marine photographer who took a photo and then Justin Bieber copied and shared it amongst his followers with no credits or anything like that. But when I spoke, you know, we talked about the different options that we could have and how do we do it. But if you're going up against Justin Bieber, who rightly or wrongly has more money than this photographer, what are you going to do? I had someone who took a really great photo that was then used by a radio personality, and when he asked me, I actually wrote a letter to the radio station and said, look, can we just get a credit? That'd be great. Went on radio and just slammed the photographer, saying he'd received all of this exposure, and he was ungrateful for the exposure he had received. But unfortunately, unless people have the resources to push things forward, it can be very hard to get a positive resolution.
Yep. So we've got a couple over here as well, but yep. Emma?
Hi there. With the rise of cancel culture, whether warranted or not, I've seen some cases like Pebbles Hooper versus Magnolia Bakery in New Zealand, and recently there was something on TikTok where a woman put a screenshot of an email online and ended up with 4,500 negative Google reviews about the business which was involved in the email. Would this lie under defamation? Would this be something else entirely? And as businesses, is there a way that we can protect ourselves from, that mass negative experience that can happen?
Yep, so reviews absolutely can be defamatory if the business is able to sue for defamation. So if you've got more than 10 employees, then you might not be able to, although if the business owner or an employee is mentioned, they may have a remedy. Often in these cases, chasing down 100 different randoms is going to be challenging. Often we look at going after the platform instead. So if the platform is posting material, the platform has been informed of the fact that the material is defamatory because these people have never experienced the business before, then we do, under the current line of authority, have an opportunity to go against them. But it is a long and painful process. So I've got about 3 of those cases currently working their way through the system. It takes forever. Google and Facebook love changing where you can sue them. So sometimes you have to sue them in Ireland, sometimes in the US, and then they change the names and they complain that you haven't got the right. I've got the corporate attorney for Facebook who denies that he's the Facebook corporate attorney and to not send him anything. So I send something to Facebook and then he emails me with a response. So I just copy him in just to annoy him more than anything else. So look, there's all sorts of different ways in which you can handle those things. It is important to get legal advice. It's also important to consider, I can spend this amount of money on lawyers, or I can spend this amount of money on proactive positive marketing. What is going to be the better use of my resources? And much as I want you to spend money with me, it might not always be the right option. So one of the things that I always look at when I sit down with something is saying, okay, if this is 1 review or even 10 reviews out of a larger number, is that really going to impact your business? If the answer is yes, then absolutely let's look at what options you have. If the other alternative is to get in front of the story, have a really good crisis comm strategy, and then look at how can we turn the narrative around, then that's really going to be your better option in a large number of cases.
Over here.
Hi, Paul. I know something that's come up a lot in your sessions in the past and that's come up a lot over the last 2 days is using influencers for brands. I'm just wondering if you can give us a quick bullet point refresh on the do's and don'ts and legal obligations of both the businesses and the influencers themselves.
Okay, so the first thing that I should say is that I have a difference of opinion with the AANA code, which presently says that if you can't really, if you're not telling the influencer precisely what to say, then you're fine. I don't think that that's reasonably accurate in accordance with the law, and that code does not have the force of law. They can regulate you under it, but that doesn't save you from people coming after you under the Australian consumer law. The position that you need to remember when using influencers is that it is unlawful to mislead or deceive a consumer. So, if someone is posting things and you are giving them free products, or you are paying them to make the posts, and it is coming across that that is their genuine opinion, as opposed to being something that they're being paid to say, or incentivized to say, by the virtue of the fact they've got a free item or a free service, then that may put both the influencer and the business who is sponsoring them in danger. Which is why, whilst you don't have to say, hashtag ad, having the influencer saying, got this product, thanks so much to Business X for giving me this free product, tried it today, thought it was amazing. That's great. You don't have to say anything more than that. But a failure to acknowledge the fact that the influencer received the consideration for nothing fails to identify to the consumer that there may be some level of bias there. And even though they might not be paid for it, even though they might be welcome to say, this is the worst thing I've ever tried, if they do, the chances of them getting something free in the future will be diminished, and therefore there is going to be an inbuilt bias there. So influencers, great. Please disclose what form of relationship there is. Hashtag SP, hashtag ad, great. But otherwise, just acknowledge the relationship.
Can you tell me a little bit about that Anna Heinrich thing, that fine, and yeah?
Yeah, so
I'm not sure if you're all across it, so maybe start from the beginning.
I'm just trying to remember exactly which one Anna was. Let me remind myself. Oh yes, that's the one.
Yeah.
So effectively, Anna Heinrich was pinged under the AANA code for having made posts that did not in any way reflect the fact that she was being paid to make them. There was deemed to be sufficient control by the company that had sponsored her to justify them having disclosed that it was in fact a sponsored post. So that occurred. There was some very angry letters telling everyone how angry they were, and that was about it.
Yeah, she didn't actually get fined.
No, there was no
anything.
fine.
No.
No, so the AANA code is very toothless. It's effectively them saying, we think you did the wrong thing. And this is the...
Bad, Anna, bad.
Yeah, but I mean, it's with any form of self-regulation, they are funded to regulate the industry by the industry. And so if they were to come out strongly and be able to impose fines or binding undertakings or any of those kinds of things, then why would they be funded? So that's the skeptic in me. So the Heinrich case really showed that even if you do fall foul of those things, the code is meaningless, because the worst that will happen is that you might get some bad press in an umbrella. I would be more concerned about individuals or more likely your competitors taking action against you under the Australian consumer law, because that does have teeth, and the penalties can be substantial.
What about that Woolies one? Do you remember the Woolies someone didn't unsubscribe and they got pinged?
Yeah, so Woolies was done by the Spam Act. So under the Spam Act, so effectively people had, this is where I was saying before, respect, unsubscribe. They had felled over thousands of unsubscribe requests to actually unsubscribe people, and were pinged for, I'm trying to remember what the exact penalty was.
It was like 1.2 million.
Yeah, it was millions of dollars for having breached the Spam Act. So that one does have teeth, and we are actually seeing, I've had probably more inquiries in the last 12 months on Spam Act compliance than I have in my prior career, because the ACMA, who regulate the Spam Act, are now, effectively they've moved past what they call the educative phase, which is where they're trying to tell people, maybe don't send spam, to a point where they're now saying, actually guys, this isn't new, Spam Act was 2010, it's 2021, get your act together. So we are seeing more and more of the compliance regimes being put in place by ACMA in relation to spam.
Cool. Are there any other questions from the floor? Yep, we've got one from Rob at the back.
At the moment, inferred consent is suitable, but I believe the Spam Act's being reviewed at the moment. And I remember working for a North American firm when it came in Canada, and we lost like over half of our email database overnight, even though we sort of had a 6-month window to try and get people to opt in. I just wonder if you have any take on if Australia might be heading that way, and what sort of timelines we might be working with. Should we be making sure everyone's opted in and we've got it recorded in a database now, or have we got plenty of time?
My understanding of the speed of that particular reform is that it's not going overly quickly. However, who knows what the speed is going to be. I would say, though, that we are seeing in pretty much every other comparable jurisdiction opt-in requirements being made mandatory, be it Europe, North America, and so it is a matter of time before it's only a matter of time until we get there. I would say that it's always a good idea to make sure that you have people opt in. At the very least, what I'd suggest is if you've got a mailing list, remembering to, once every 6 months, send something out to your database saying, hey, just making sure we're still relevant and interesting to you. If you don't like being on this list, here are your ways of opting out, or here's how we can better tailor our communications to what you're interested in, because at the end of the day, you want engaged subscribers. I think that is definitely best practice, but I don't think you need to rush in the next 6 months to do it. I think that it's unlikely to come in the next, it may well be legislated in the next 12 months, but I don't think it will have an operative date within the next 12 months.
Yeah, we've got 1 and 2. 2 questions. Any others? Anyone else got any other questions? Just so we can... Okay, it looks like those are the last 2.
I'm just following on that last question. So if someone lives in Australia and they're covered by the Australian law, if we have a subscriber from America who has different laws around unsubscribes and stuff, what does that come under if, like, they get cross at us because we haven't unsubscribed them properly? Is it American law or Australian, or...?
So this is, we've seen the most case law on this in relation to the GDPR. So the Europeans decided that they'd be a little bit broader in terms of how they were going to handle things. And so there what they've said is if you are, in reality, marketing to people in that country or actively monitoring the information of people in that country on more than an incidental scale, then you are captured by their laws, and they have fined companies outside of the EU for failure to comply. So if you are an Australian company providing Australian products and services and information relevant to Australia, and someone who just happens to be interested and lives in Prague signs up to your list, don't stress. If, however, your site is either of global relevance or you happen to have a French language translation version of your page, or you quote things in US dollars, then I think you do have to be aware of the extraterritorial reach of the countries that you're targeting.
Last question.
I've just got a question about building lookalike audiences through some platforms like Facebook. And often it requires you to put in demographic details of your, say, even your current clients, so that they can then market not directly to them, but to someone similar graphics or features. How does that play out in the Privacy Act? Is that something that approval from your existing clients? Is it something? Yeah.
So the word.
Because there's a third-party software, I guess, and yeah.
So if you are using someone's personal information for that process, you will need to inform them that you're doing it. However, I do think that it is a grey area as to whether or not the prohibition on direct marketing applies, because you're not actually marketing to the person whose information you're using. You're marketing to someone else who just happens to like the same kinds of things. So whilst you would need to say to me, Paul, we're using your information to target some marketing to someone else, you don't need my permission to do that. You certainly have to tell me, though. But the person who's actually receiving the marketing isn't me, so I don't think that is necessarily within the strict definition of direct marketing.
Okay. Last call for any questions or for Paul's free legal service, which ends in 5, 4, 3, 2, 1. Many thanks, Paul Brennan. You're always welcome back.